you. Good morning, everyone. The appellate court for the state of Connecticut is now open and in session. We will now hear the matter of Green versus Paz, AC 44494. I am Judge Mall. I have the pleasure of sitting this morning with Judge Clark and Judge DiPentima. We are conducting this hearing virtually using the Microsoft Teams platform. I would first ask that everyone participating in this proceeding identify themselves for the record, starting with the judges, then the appellant, then counsel for the appellees. Again, I am Judge Mall.
Good morning, Judge Clark.
Good morning, Judge DiPentima.
Courtney Green, the self-represented plaintiff/appellant.
Attorney Cameron Atkinson for the appellees, Brittany Paz, Norman Patterson, the Pattis Law Firm.
All right, thank you. A few additional preliminaries before we get started. When you are not speaking, if you would kindly silence your microphone, but leave your video on so that we can be sure that we don't lose anyone. Mr. Green, you of course can just leave the settings as they are. Let me state the obvious. When you are not speaking, if you would kindly conduct yourselves as though you were in the physical courtroom so as not to create any distractions for the other side or for the judges. Each side will be permitted 20 minutes of argument. Mr. Green, you are entitled to reserve a portion of your time for rebuttal. Just let me know if you wish to do so. So, Mr. Green, are you ready to proceed?
I am.
And you wish to reserve any time?
Yes, I would like to reserve 5 minutes for rebuttal, please.
All right, you got it. Go ahead, sir.
Good morning. First of all, this case right here involves several different issues regarding the exoneration rule, whether public policy has accepted that as a requirement for a defendant to prevail, namely get his case exonerated or overturned before he can commence a malpractice suit against defense counsel. Two, whether the trial court had jurisdiction to hear the matters in this case, and what did the trial judge improperly misconstrue the general statutes, section 52-577. And I propose to the court if we can have the questions in order, so just to keep you on track. This is my first time in front of the appellate panel. To begin, Bozelko v. Papastopoulos controls this case, and that's a Supreme Court case where the plaintiff initiated a malpractice suit against defense counsel. The plaintiff was unsuccessful. The plaintiff's conviction withstood numerous post-conviction attacks. However, the Supreme Court granted summary judgment to the defendant's favor because the plaintiff failed to produce expert testimony, not because of the plaintiff's failure to exonerate his or her case. So with that said, in this matter, there's been no ruling from our Supreme Court that plaintiff must get his case overturned before he can be exonerated. And that's the position that I feel is warranted in this case. I know a lot of Superior Court decisions have applied the exoneration rule, but I think that isn't appropriate given what our Supreme Court has said. And there's several decisions from our Supreme Court, Mayer v. Beaufort, Grimm v. Fox, it's Bozelko. They all require 4 elements, 4 cardinal principles. 1, attorney-client privilege relationship. 2, the attorney's wrongful act or omission. 3, causation, and 4, damages. There is not a 5th element or / exoneration rule that a plaintiff must prove before he can prevail or bring a malpractice lawsuit against criminal defense attorney. And moving on, and then how we establish causations, which I see that a lot of trial courts are relying that it's incumbent that you should to show damages and cause an injury that a defendant has to get his case overturned. But to prove causation is 2 principal elements, causation in fact and proximate cause. But when in the matters when we're establishing injury, causation, and damages from from previous litigation, it's looked at through the case within the case lens. And our Supreme Court has reiterated that in Margolin v. Claiborne and PC. And it's objective what the result should have been by a particular judge or jury, not actually what it would have been. And that can be looked at, basically, you look at the causal connection between the attorney's conduct and the complaint alleged by the plaintiff to see if it coincides. And moving along to public policy, the policy set forth in General Statutes 52-577, that's the policy that we're going by. And it states that you have 3 years, and paraphrase, you have 3 years to bring a malpractice tort against a criminal against an attorney, period, for malpractice. That's the policy. There is no exoneration rule. In our Supreme Court, several Supreme Court decisions from Burnham v. Administrator, Lewis v. Gaming Board Policy, they counseled our courts to not entangle ourselves in public policy concerns. That's left for the legislature. Until the legislature puts in place that we have to be exonerated, then that's just simply what it is. That's the policy set forth. There is no exoneration rule. And not only that, our Supreme Court, our appellate court from Schuster v. Buckley, I believe it's from 1985. It says when malpractice is brought, the tort statute of limitations apply. And I think that is key that we adhere to this, because now, if I were to file my lawsuit against the defendants after the 3 years, which I found out maybe about 2017 or 18 about, Attorney Pattis's wrongful act during his representation on me on appellate court in my criminal proceedings, I think I had 3 years. So 3 years from 2017 would be 2020. My habeas against defendant Pattis isn't until 2022. So therefore, I would be barred by the statute of limitations. And if I filed a lawsuit in 2022, the defendants would say, well, I'm barred by the statute of limitations. And quite frankly, they would be right. So the 3-year statute of limitations apply to this. As far as jurisdiction, their rightness is the doctrine of justiciability. And there's four elements of justiciability that I have to meet. And I met those, and the underlying pendency does not stop this case from being justiciable. One, excuse me for a minute. One, there has to be an actual controversy. 2, an adverse interest in the party, which we have here. 3, this court is capable of adjudicating the matter. And 4, it will result in practical relief to me, because I'm assuming that it would establish that there is no exoneration rule, meaning I don't have to get my case overturned before I can commence a lawsuit against the defendants in this case. Pretty much, and not only that, our Supreme Court in Mayor says that if a malpractice suit is predicated on pending underlying litigation, that claim is still right even without judicial determination. And I mean, that's, to me, is clear as cut that they have spoken already. There is no exoneration rule, and underlying litigation, it can still be right without judicial determination on the previous litigation while it still exists. And that's pretty much as far as those matters. And then regarding stare decisis, I know several superior courts, not in New Haven, have applied the exoneration rule. And I believe in Appendix A55, Judge Abrams, in his decision, he says that it recently gained recognition in Connecticut. However, I don't think that's true, because again, as I reiterate, the Supreme Court has not made that a requirement. And I believe, yes. Can't hear you.
Excuse me. Sorry, sorry, sir. I hear your argument, and basically you're saying that the exoneration rule has not been adopted, but by the legislature, and therefore shouldn't be applied by us. But what do we do with, you cited the case of Taylor versus Wallace. And I just wondered if you had any response as to what we do with that case, which did appear to recognize the exoneration rule.
Yes, correct. You're right. Thank you for the question. It does. Taylor v. Wallace does not undermine Bozelko v. Papadopoulos. I mean, I have seen that they thought the rationale in that case was appropriate for that until a defendant can get his case overturned. But yet, I'm relying on Bozelko, and I believe that if we stick by the Taylor court, then essentially Taylor will be overruling Bozelko, which the Taylor court has no authority to do such. So I think that's where the conflict comes in at. If we just stick to what the legislature and our Supreme Court has said and burn them, to further question public policy to the legislature, to not entangle ourselves in legislature's policy, we wouldn't be in this whole convolute of the law, whether the public policy has been exonerated requirement or not. I mean, other states, and I know the defendant cited in their brief, from maybe Kentucky, California, they specifically have adopted the exoneration rule. So there is no argument. It says it from Supreme Court and it says in their legislation. So there is no argument. If we were in one of those states where it has specifically been adopted, then I would understand that I would have to get my case overturned. But in this jurisdiction, there has not been an adoption of it. And even in the Superior Court, Judge Levin out of New Haven, and I think in the matters of Miller v. Barber, he specifically cites there has not been an adoption of the exoneration rule in Connecticut. So, but they still do it. And I think they're essentially overturning our Supreme Court's decision of what a malpractice requirements, with the 4 malpractice requirements, are adding a 5th element that has not been adopted.
Thank you. Thank you for that response, sir.
No problem. Thank you for the question. May I proceed? Any more questions? No? No?
Oh,
okay. Yes, and back to what I was saying, the problem with stare decisis, I mean, we already know the decision, let the decision stand as it may be. In Bazelko v. Papastokris, Mayor v. Mayor v. Florkin O'Neill, Grimm v. Fox, all these, I understand some of those, including Mayor and Margolin, they involve malpractice suits from civil, but Bazelko is from criminal. Schuster v. Buckley stems from criminal, and it says the tort statute of limitations apply. Now, back to the policy in General Statutes 52-577, this does not involve a civil rights, this is not a malicious prosecution suit that's being commenced in front of this court. This is a civil malpractice. So I understand the policy that had this been a malicious prosecution, I would have to require until I get relief before I can commence a suit. But that's not the issue here. In 52-577, the policy that, this court is bound to uphold, because this court acts as a surrogacy to the legislature. So the policy set forth in 52-577 requires 3 years from the time of the time of the action complained of, and not when the injury occurs. So with that said, I have no more. I'm good at this time, and the opposing counsel may proceed.
all right. Thank you. All right, Attorney Atkinson, if you would, there you go. All right, you may proceed.
Good morning, Your Honors. Attorney Cameron Atkinson for the respondents. Taylor v. Wallace indisputably governs this case. This arises from a habeas action that our office appealed on behalf of Mr. Green. There was conversation at the appellate court before this court during that appeal as to whether Attorney Pattis raised the right vehicle for presenting Mr. Green's arguments in that case, and Attorney Pattis openly conceded on the record that he had used his best professional judgment to identify the issues that he thought were relevant, and that he would advise Mr. Green to file a habeas against him for deficient performance if he had raised the wrong vehicle. Mr. Green did that, and as of this morning, when I checked the various matters that Mr. Green has filed in the habeas court, it appears that Mr. Green's habeas is still pending, and it's set for trial this August. As such, because there is still a pending habeas case, Taylor v. Wallace explicitly precludes Mr. Green's claims as a jurisdictional matter. The jurisdictional issue that Wallace was concerned about was that of issue preclusion. Relying on Heck v. Humphrey, and analogizing to a tort of malicious prosecution, what I think that this court gets at in Wallace is the standard for defense counsel's effective performance. His professional responsibilities is constitutional in nature. Because it's constitutional in nature, a failure, deficient performance, or malpractice on the part of a criminal defense attorney results in the reversal of a conviction. Because it results in a reversal of a conviction, allowing malpractice suits to proceed, as this court recognized in Taylor, would essentially permit collateral attacks on convictions that may not go anywhere. The policy that this court was concerned about in Taylor, that the Supreme Court was concerned about in Heck, is essentially having case after case after case flood the court system when there is no actual deficient performance of counsel. The fact that the crux of this matter is that Mr. Taylor needs to show that deficient performance was so deficient as to result in his current conviction and to keep him there. And I understand that the facts here are a little different as opposed to if we were litigating straight from Mr. Green's conviction. We're looking at Attorney Pattis's performance on a habeas appeal. There's no indication that the facts would come out any differently. That's something to be threshed out in the habeas court, and that's where it properly belongs. I did want to address Mr. Green's point about the statute of limitations. That was not an issue at the trial court, and it's not an issue that should control in this appeal. I believe our case law clearly establishes that a cause of action accrues when there's an event. When the cause of the statute of limitations doesn't begin to run until the cause of action accrues. The cause of action that Mr. Green's seeking to state here, just like a claim for malicious prosecution, isn't going to accrue until the end of the habeas proceeding, just like a claim for malicious prosecution wouldn't accrue until the end of a criminal trial and a verdict of not guilty. There's no issue as to the statute of limitations here. Our law clearly keeps open this claim for Mr. Green should he prevail in the habeas court. And finally, with respect to Bozell, Bozell was a summary judgment case. It doesn't appear that the exoneration rule was ever raised in Bozell. It does, as I believe this court acknowledged in Taylor. Taylor was the first case within the Connecticut appellate system that actually considered the exoneration rule. It adopted it, it controls, it should apply here, and we would ask that this court affirm the judgment of the trial court. Thank you.
All right, thank you. All right, Mr. Green, you have 5 minutes.
Thank you. Just to go back, in Taylor v. Wallace, I'm not sure at what point, but it's somewhere throughout the case, to my recollection, they referred to that. It was a note in there that said that this case, meaning the exoneration rule, has not been adopted or considered by an appellate court in this jurisdiction. Just to note that. That's the Taylor v. Wallace case. It was somewhere in there that was noted. Also, back to what the appellees state, There is no tolling of legal malpractice torts. So I disagree with him strongly based upon the statute of malpractice torts. You have 3 years to file with the active complaint of. And if you look in the policy, it says not when the injury occurs, which the trial courts and the appellees are, insinuating that injury doesn't occur until I'm actually getting my case overturned and Attorney Pattis's performance is being deemed to be inefficient. However, moreover, this is a civil tort. It's not to be tested in the criminal arena. So those are two different distinct actions. I mean, my habeas seeks to vindicate my constitutional rights. And even so, I asked this court to look at Attorney Pattis. If you look at appendix A67 through A68, Attorney Pattis, he's asked by one of the appellate court judges, and he says, I forgot to drop the bigger picture. I could have raised a broader issue. So there were no questions, Attorney Pattis, about forfeits or promises. And Attorney Pattis says correct, which is the crux of this claim. When instead of raising medication on my habeas, on my appeal, he should have raised forfeits or promises. And Attorney Pattis concedes, and he also acknowledges that he felt that that appellate court judge's civil class. And so, I mean, you can see it's there. Not only that, and just because I have pending underlying litigation, it does not stop. It does not mean that Attorney Pattis wasn't deficient. Excuse me, his performance was. It doesn't mean that. That doesn't mean there was not malpractice because I have underlying litigation in the criminal field still. I mean, so with that said, I'm done. If there are no more questions, I'm done.
All right, thank you. I see no questions from my colleagues. So thank you both. The court will take the matter under advisement. The court will stand in recess and we will reconvene in the courtroom. Thank you.
All right, thank you. Have a good one.